There we go. All right, now we're recording. Welcome everybody. It is, well, it's September 9th. Whatever number of sessions we've had, this is that number. So there we go. We have a full draft, and yes, Dawn, as you were saying, this is that draft, the one that I have been putting together. Oops, there's Kelsey. Cool. The one that I've been pulling from the OSB version and modifying to, as the lingo goes, operationalize, or whatever we want to say, contractualize, just make it something that OPDC can actually utilize. So, yeah. So I think the original plan was to go through the back half of parent representation today. That was the plan prior to me getting a full draft, at least, knocked out. I want to emphasize this is not a final draft. It's nowhere close to a final draft, but it is at least an attempt at getting all of the OSB standards revised and kind of put into what we've been, to a degree, using like the whole should and must language to try and pick which ones are things that might be contractually obligated versus which are aspirational. So I'm happy to go back to that back half of the parent representation portion again, just because we have not looked at that really at all yet. You in? Unless anybody else thinks that we should start elsewhere. Hello. Just as a note, I'm actually not sure who it is who just joined us.
It's Jen Kinsey. Sorry, Teams is being an absolute pain in my butt.
No worries. Can I rename you? I cannot. Oh, well. That's fine. We can do without that. Okay. Jen, do you have do you have a portable copy of the current draft that you can reference?
I do indeed.
Sweet. All right. Well, then we can just keep moving forward. All right. So does anybody have a preference beyond or other than just going back to, I think we had left off, we were working on like standard 4 or 5 somewhere?
So for the last meeting, you asked us to get through 8 to 10, which we sent in. But as of the end of so the meeting I missed, which was the 27th, for that meeting, you had asked us to send in standards 8 through 10 in the parents with our notes. So we haven't reviewed those yet. We're still on the 4 through 7.
Okay.
I'm asking. I wasn't.
I thought you were okay. So we virtually never have been able to get through all of the desired standards in our actual like meeting sessions that we want to. So we can hit 8. I think that because 8 and 9 we aren't doing 10 because 10 is appellate and this is not intended to cover appellate work. Sorry for everybody's screens jumping real quick. But if we want to take a look at 7, 8, and 9, I think that works for me. I think for the most part, those are going to be fairly quick. And then I know the other big thing that I brought up last time and definitely want to nail down is how to deal with guardian representation. And not guardians ad litem. I think that would be a different set of performance standards, not the same as attorney representation. And we don't have qualification standards for, I guess, if you're dependency qualified, you can be the GAL for a client in a dependency case. And if you're TPR qualified, you can do GAL representation. I'd say representation. It's not even really representation. You can be the stand-in, right? But I don't know that these standards apply to GALs. I don't think they do. I mean, the role would be something akin to a child's attorney role without the actual representation, is how I conceive of it. Does that make sense?
Yes, but I think you should consult with Emily Cohen about what those standards should look like.
Oh, okay.
If I am not an expert in that field, in that
Gotcha.
area
Okay.
of law.
Fair enough. Okay, then has everybody had a chance to look at, let me describe it first. So the way I looked through each of the standards and I kind of just like, okay, is this likely to apply to representation of a guardian equally as it would to representation of a parent? And by and large, across the board, they all seem to apply equally, except the roles and the relationship. Those are where there's a distinct difference, and simply because there is less there's less procedural protections over a guardian, and they sometimes face fewer challenges. Like you don't need to explain what the allegations are against a guardian if they're the one that the court appointed in the dependency case, because there's no allegations against them, right? Like if they got appointed as the guardian of a child and somebody then contests that guardianship to undo it, there's no allegations against the guardian. There's no jurisdictional bases with respect to them. So you don't have to explain something that doesn't exist there. Jennifer?
Well,
No, but
have,
Sorry, I meant Jen Stoller. I'm sorry.
it's
go
hard.
ahead. I also have a question. Go for it.
I mean, we also have cases where a guardian is the subject of the petition.
Yes, I wholeheartedly agree with you there. So I think if I remember, let me pop back up there. I think I actually said if there are allegations, you have to explain them. But it's worded differently because of that. No, this is parent. Wait. This isn't the right copy. Oh, darn it. Hold on. I'm going to close this out because this is not the right copy.
I can forward you the email.
Essentially.
Sorry. Sorry, what?
Go ahead, Jen. Go ahead.
Oh, my question was essentially the same, but I think that problem could be looked at just in definitions, like when you define what a parent is, parent or guardian who is the subject of a dependency petition, as distinguished from guardian as the final outcome of a petition. Does that make sense?
Right, and I don't know that we necessarily can split things out that many different ways. Hold on, let me get so I did throw in here. Yep, this is the right copy. I was worried I might have the wrong one, and I was right. Okay, let's grab this.
The guardian who is the subject of a petition should be treated identically to a parent, right?
Yes, except that they don't have some of the procedural protections. And importantly, you can't have a guardian ad litem over a guardian. The guardian ad litem statute explicitly says parent. Dawn.
Well, I approached this, I have to say, I boxed myself in. When I approached it and put in my comments, I was thinking that we had a guardian, we were representing a guardian in a conditions and circumstances case that is moving towards, even if they've resolved it, and we are in the disposition. We've gone through adjudication, disposition, and now we're in ameliorating or solving conditions and circumstances. Unless and until someone files the motion to remove the guardian, we should be treating them like we would be treating our parent clients. And then perhaps we need a separate set of, then perhaps we might need some additional standards for the situation where there is a guardianship in place, a 419B guardianship, and someone tries to files a motion to vacate the guardianship.
Right.
And then we're representing them in almost everything. Our relationship with the guardian is the same, but sometimes the guardian's like, yeah, I don't want to be a guardian anymore. I'll step away. And so there might be a standard that just addresses that type of case, which is fairly rare now. And that's done with my statement.
No, that's fine. So I think we're not far off. I will say that nearly even splitting them, nearly all the standards between guardian and parent are identical. It's just that there are a couple that clearly did not apply. There's no standards for how to deal with, like, for instance, there's no standards for how to deal with a guardian ad litem when you're representing a guardian, because the court has no authority to establish a guardian ad litem for a guardian. The authority doesn't exist. But I had put notes to myself in about, all right, so what about an incarcerated guardian? And I'm still gonna leave that in unless y'all think I shouldn't, because the court might just go ahead and vacate that, but it also might not. And if it doesn't, you still got to do the work.
I think I provided feedback in a comment to you along those lines.
Yeah. And I agree with you there. What I was trying to, the only things I wanted to make sure we excised completely are things that would never occur. Things where it just does not make sense for this to be a performance standard when representing a guardian, because it can't happen. So let me see if I've got the 4 standards for parents' role here. Guardianship, the only one that is removed is the one about the guardian ad litem. And then with the relationship, there's, I think, 6. There's 6 for the parent, and also 6 for the guardian. But if I remember right, there's a modification to language. Yeah, if the petition alleges deficits against the guardian client's lawyer must clearly explain the allegations made against the parent, the guardian. So I split what's up on the screen now is for parents. I split A into 2 pieces to make it clearer and more understandable. If there's allegations, you have to explain them. In all cases, you have to explain the nature of the proceedings and what things are going to happen in certain hearings. And then I think the any client of the rights, role, responsibilities, relevant state and federal. Yeah. I removed for guardians you have to take diligent steps to locate and communicate. Should I not have removed that? Because I feel like if you don't know where the guardian is, is the court gonna remain having the guardian on the case? Like, this just seems like such an off the wall, like, holy cow.
Well, think about it like this. There's a guardian. The guardian's been caring for the child for months, years. And then the condition and circumstance surfaces. Substance misuse.
Sure.
They get arrested, right? The judge might really be reluctant to vacate the guardianship unless somebody else moves to it. I mean, I can see somebody like Referee Hughes was like, well, let's see how this plays out. The kid's 12 and living in the guardian's house with the cousin right now, and maybe the guardian's going to be released in a couple weeks and everything's just fine. So until the judge removes us, we're not going to, or we have a solid basis for a motion to withdraw, then it's the same situation.
All right.
Or if you had a situation where a parent decided to file to, overturn a guardianship and the guardian freaks out and takes the kids and takes off, then the judge isn't going to do anything while the kids are missing. So you're going to be stuck on that as well.
Okay.
Well, and I guess, Kevin, here's the situation. In a motion to remove the guardian, OPDC is going to give we all agree the law says that the guardian gets an attorney in that situation too, not just when DHS is filing.
Correct. That has been our practice, is that we will authorize counsel for the guardian.
Except in Washington County. There was a case I had that did not do that.
And I just represented a dad in a case where the guardians did not have lawyers. I represented the dad.
We don't always necessarily, the court's not always doing what they should be. Our position is they are parties, they are named parties, and there is an appointment statute saying that if the nature of due process so requires, they get an attorney and we pay for it. So that may just be the courts need to understand better what the law says on that front. But it's a little hard for somebody to pull that. I mean, child's attorney, if they're aligned with the guardians, might ping the court and say something, but I can certainly see why parents' attorneys might not necessarily want to raise the issue of, hey, they should really have an attorney. But that has been our standpoint. I've never represented a guardian on a motion to vacate or motion to modify. But I have brought a motion to vacate, and the court appointed an attorney for the guardian in that case. And my understanding was it was fairly routine. But I've also never practiced in Multnomah or Washington. So.
It sounds like we all agree that they would get a lawyer. And so the question is, if they have a lawyer, do we have the same responsibility? Must we make reasonable efforts to track them down? Right. And I think if it goes for the parent, it should go for the guardian in terms of our obligation.
I can put this one back in. I am convinced. I'm going to pull it off to a different screen so that it's not quite so huge. Wait, if I do this here, yes, that worked. I can have it my size on one screen and a different size on a different. Okay, so I will pull that. And I'll go back and see if I need to fix. Let's see. That came after the federal statutes. Okay. Okay. The other thing that I was a little bit worried about was whether the muzzling statute applies to guardians, and it does. It applies to everyone except the child, apparently. So, do you know what I mean by the muzzling statute?
No.
The if your client doesn't show up, you can't talk.
Okay.
So that applies. That at least my read of the statute, because it says person, it applies to everyone except for the child who is the subject of the petition. So, okay. So I'm gonna, well, maybe Annie might be the one to have to think about this, as to whether we need to have a different set of performance standards for the guardian who is established by the juvenile court. I think it's fine, because the only thing I can think of that you wouldn't do for that guardian is explain allegations against them if there aren't any. Is there anything else that would not be part of the roles or responsibilities or relationship?
I mean, I've had a case where I didn't represent the guardian, but the guardian was the grandma, and it was kind of a race between the grandma until DHS decided they were going to file a motion. They were offering services and conditions and circumstances for the grandma too. So,
Okay. Oh, like, wait, did they file a petition against the grandma?
they filed a petition. The petition's as to the child, but the conditions and
Sure.
circumstances covered the
Right. No, I
mother,
mean,
the father, and the guardian.
so I'm talking about a situation like, yeah, okay. And if there were, well, DHS isn't a party once you're post establishment, so yeah. Okay. That's what I'm thinking, is that late stage guardian, is there anything else that you wouldn't do for them that you would do for a parent or a guardian against whom DHS has? I mean, and I know that the petition is against the child, but the allegations allege deficits against the parent or the guardian. Um,
No, actually, you might do more for the guardian because you might advise the guardian that unless you get on top of, you are at risk of someone filing a motion to vacate the guardianship, which the parent is not at risk, right? You have to.
right. Okay. All right, then I think we're good, and I'm gonna leave the split as it is. Yeah. Okay. And let's head to standard number 7. So I think that's roughly where we left off. All right. For the remainder of the document, anything saying parent means both parent and guardian. And I did throw a definition of what parent is up in the preamble so that it was clear who we're talking about being represented. I gotta say, the one weird area there is the putative parent, largely because DHS doesn't always know who a party there is, but I think we have to draw the line on a putative parent who is named in a petition, just because otherwise, theoretically, anybody might be able to say, "Hey, I'm involved," and I don't think we would be able to give them counsel. I think they have to find a way to get on the petition for us to authorize representation. And that is not, I think, something that is part of what we can deal with on this, in this work group. That would be a different discussion elsewhere about where we draw the line on putative parents. There may be, with the passage of portions of the Uniform Parentage Act this year that may call in some of the that may change things to an extent, but I'm unsure how or to what degree. So, all right, court prep. Parent client's lawyer should develop a case theory and strategy to follow at hearings and negotiations. Once parent's client's lawyer has completed the initial investigation and discovery, including interviews with the parent client, lawyer should develop a strategy for representation. Anybody think, I mean, this is saying should, not must. Kinsey?
This
I had a
is
note.
an ongoing thing. Oh, sorry.
Sorry, go ahead.
I have a little flag that said, should, whenever possible, develop a case theory and strategy to follow at hearings and negotiations. Maybe I'm just splitting hairs, but sometimes it's not possible.
Why don't I see I don't see a flag on the one you sent
I'm looking
me.
I emailed you.
Yeah.
And then it says standard 7A. My copy of the standard 7A, and I put a yellow highlight with a flag that said, this should say whenever possible.
Dawn, it sounded like you just said this shit should say whatever possible. And so I think everyone else heard that too. I'm just throwing that out there.
I don't know what's going on.
I did not say that for this recording.
Not,
for the benefit
I do
of
not
this
see
recording.
that flag. So I'm not sure what happened there, but it's not on mine. But well, so I think that whenever possible makes but we've been trying to put musts in the bold stuff, and Jennifer Stoller, you're nodding your head, so I'm assuming that's your comment.
That's my comment. Like it's not a must. It's a should, and sometimes shoulds don't happen or shits don't happen because they can't.
Well, so I said should say too. So done and done. I have nothing else to say on that.
So here, I'm actually going to push back because it doesn't. I mean, why wouldn't this be a must? Let me put it that way.
Only if you add whenever possible.
Is there a reason? Is there a circumstance where you shouldn't have a theory and strategy? Right? That theory and strategy might be informed by the fact that you can't get in touch with your client. But is there ever a point where you wouldn't develop one? You might have to modify it or reconfigure it as you go. But is there a circumstance where you don't have a case theory or strategy? You just don't do it.
Well, if a case theory and strategy includes, we'll see what they show up with.
That could be the strategy, right?
Right. So as long as we're not thinking about in terms of themes and stories and catchphrases and labeling people, like I'm okay with that. But I mean, the standard should be anchored in reality as well as require us to be good lawyers.
I mean, I agree. I'm like, part of that to me is at some point you've always got to have some kind of a strategy. It's hard to necessarily say what is the how good of a strategy is it, right? That may be something that nobody outside of the individual attorney can really, I mean,
I think there's a level of adaptation that happens as well. So it's not like you meet them at the shelter, you go through, even if you develop one for the contested jurisdiction, that is most likely going to change and evolve as it goes on. So it's not going to be the same at each and every single hearing for most of our cases. So I don't know if adding something in there of adapting the strategy or adapting the case theory to fit the ongoing facts for each hearing or something like that would make sense. But I do agree that even if your strategy is to go in and say, Your Honor, I have nothing to add, that's still technically a strategy. You're not showing up going, I don't know.
And I mean, to a certain degree, I think of this from the child's attorney standpoint. And one of the things that we would want to try and minimize is, like, think of this in the frame of the child's attorney, right? What we're saying in this paragraph is go in, like, you should be preparing for the hearing, knowing or having an idea of what your strategy is going in, as opposed to what a lot of attorneys have been doing and we don't particularly like, which is acting as that neutral arbitrator or arbiter of what the facts are and telling the judge, here's what I would do if I were in your position at the end of the hearing, right? Like, instead of having no strategy but just, yeah, let's see what the facts are, and at the end that's when I'll go ahead and say, here's what I think should happen. This is the be proactive, develop some kind of a strategy. Uh, there's no comment as to how fleshed out it needs to be. Maybe I'm off base though.
No, Kevin, I don't think you're off base. I think that is very reasonable, and it's shocking to me that we have to say that, but okay, if we, it just seems like a big duh to me. But as I practice in other counties, I know different counties do things differently. But I will say the legal representation, I've rarely met a lawyer that doesn't have some sort of a plan, harebrained as it may be. Some sort of
I
plan.
wish I could say that.
Okay, well,
I was gonna say, I think the only situations where that might be difficult is for shelters, because you've got 17 other things going on a hearing release. You've only got 5 minutes to review the PCR before you go into a shelter. But otherwise, yeah, you're usually at least in touch with a caseworker, if not your client, and seeing discovery and things like that, so you can have an informed position, even if it changes in the middle of the hearing.
but I think even at a shelter, you have a case theory. I mean, again, don't know what happens in other counties, but in my county, the AG's office communicates with me and tells me this is what's going on. This is how this case came about. The kids are aligned or they're not aligned, and here's why, right? Like kid A accused kid B of sexual molestation, so they're not aligned or whatever. And so I have all that information so I can get it out to the lawyers. And I also have contact information, and we get our things filed by 11 a.m. and we have to be in court at 1:30 p.m. And so we, make every effort to get a hold of our client before court. And the strategy is often just, look, I need to go over the petition with you. I need to make sure you understand your rights. I need to make sure everything's spelled. And this is what this hearing is about. And you don't have to, I'm just going to deny the petition today. And then, we'll talk more. Don't worry. This doesn't mean you're not admitting anything in this petition, and just kind of,
right.
I mean, that may be your strategy, right? Like, I just need to make sure you understand your rights, and we need to talk about whether or not we're going to have a shelter hearing, right? That's all today's about. And so, yeah, it's a nightmare. It can be, depending on who your appointment is for that day, but it's still a strategy. Again, maybe not the best strategy, but it's what you can do with the limited time. So there you go.
I mean, that's true. If you're talking about the procedural, I need to make sure that you understand what's happening here. Yeah, that counts as a strategy. Yeah.
Yeah, I think you're making it not too complicated, but I mean, I agree with you. When I think about strategy, it's not always like, do you know your rights? Is your name spelled right? Like that.
Right.
But that can be the strategy given the time frame and given what you have to do.
And even the strategy of, I know that the judge isn't going to be like, we're not in a good place. We don't have all the facts to have a great argument for placement today at shelter. that's a strategic decision. We're going to ask the court to set a placement hearing on a short, immediate docket, right? So it doesn't necessarily need to be like we can have those big, longer term pieces. I mean, strategy separated from tactics, right? We're not like you don't need to have everything worked out, but you do have to have an overarching strategy. How do I think I'm going to defend this? Okay. Um, Parent client's lawyer should timely file all pleadings, motions, objections, and briefs and research applicable legal. Oh, Tara is trying to join the meeting. I'm. Let me see if I can email it to her real quick. So parent client's lawyer should timely file all pleadings, motions, objections, and briefs and research applicable legal issues and advance legal arguments when appropriate. This may be duplicated by C. I may have accidentally done. Anyway, somebody was that you, Dawn?
It was, but because C duplicates it, I think you've changed it to must there. So
Okay.
I'm fine with that.
See if I can just.
Well, it's not necessarily duplicative, though very similar, because one is saying answers and responses, motions and objections, and discovery requests. And it's
okay.
One's more
They're
expansive, but it doesn't include all pleadings.
Targeted at different things a little bit.
So
sorry,
combine and simplify.
Nope, B and C, not C and D. All right, I'll put a note to that effect. Where's the comment? There it is. All right. Okay. Maybe I'm forgetting. There we go. Is that Tara? Nope. Is that just Jen back? Hold on.
This is Tara. I am unable to get in via the Microsoft Teams, however. So that's fine. I'll do phone.
I'm sorry. I don't know why that didn't work for you. Okay.
I mean, I get to see my lovely face.
All right. Okay. So combine B and C. D, parent's lawyer must communicate all settlement offers to the parent client and discuss their advantages and disadvantages with the client, including the rights that would be waived by a decision to admit facts sufficient to establish jurisdiction and the impact of timelines established. Thoughts on this?
It sounds good to me.
We pulled it straight. I pulled it straight from the OSB standards. I'm not positive that the original OSB said must, but I felt like this was like, this is a must. Okay. It is the parent's client's decision whether to settle. The parent client's lawyer must be willing to try the case and not compromise solely to avoid the hearing. I have one, and this might be controversial. I'm not positive. The controversy is, personally, I think people don't include children's attorneys in settlement discussions. And a child has just as much right as a parent to argue against jurisdictional allegations as the parent does. So I'm not sure that it necessarily changes the language of this, other than it's not entirely the parent-client's decision whether to settle. So I'm not sure how much we want to have that language in there.
Where
sorry,
just to point me to page, or because I do have something to say
sure.
on that, but I just want to be following.
We're on page 34 of the current draft. It's standard 7E.
Okay.
So
And this is getting at the whole, you don't get to override your client's settlement decision. I'm just like, is it really their decision though? Because the child, or I mean, the other parent, I mean, you could have a substance abuse allegation against mom that dad fights and says, no, mom doesn't have that substance abuse allegation. Because one of the ways I, as father's attorney, can defeat the petition is by having the court fail to find any allegations against mom.
Well, we do that yeah. I mean, that's pretty common in our area.
Well, isn't there a case?
Let's go with Jennifer Kinsey first.
I was just going to say it might be easier to just say it's the parent-client's decision whether or not to enter admissions, because that's their own thing that they're in charge of.
Yeah.
The result of the case is separate from that.
But isn't that part of what you're saying, Kevin, is that the kid can still object to that, right?
So I don't think that the kid or the other parent can object to the parent making a statement saying that they believe this paragraph to be true. What they can object to is the court considering that for anything more than essentially hearsay, right? Or a non-professional opinion or something along those lines. Like what I mean, if I were representing kid, I might say, Your Honor, I'm going to object to that based on the witness has not been sworn and there's a lack of foundation as to how they would understand that this is a safety threat sufficient to invoke court jurisdiction, right? Like there are other ways that it might happen. I think maybe the enter admissions is a good, like it kind of gets closer. I don't know.
I think the entering admissions is closer because there is a statute, maybe case law on point, where if the petition or if something's going to get dismissed, there is, I think it's 7 days, right? So for any party to object, and then that allows them to have the burden of proving it. So you're right. The kid's lawyer could be having that burden. I don't think the same is true for an admission. So basically, I'm just saying I agree with her.
I would agree because with an admission, like if one of the admissions is, for example, the child is beyond the parent's control and the child is going to stop the parent from admitting that. And we've had cases where one parent is trying to prevent another parent from admitting, this happens all the time, that she's a victim of domestic violence. And the dad's like, well, I object. And so, and the judge is like, yeah, and so I think you're right about the admissions piece.
Okay.
I don't think I've ever had anyone object to admissions before. That's entertaining.
Oh, come join us.
We have.
Yeah, we have too.
It's a fun day.
The DV is a huge one for us. You know, mom admitting that she's a victim of dad's domestic violence.
Okay. Anything else on E? Okay. F, parent client's lawyer must prepare the parent client to testify. I think you have to prepare them. If the case is going to go to trial, I think you have to, because you don't get to control whether they take the stand.
Well, again, that should clarify that unless the parent client declines the opportunity to be prepared. You cannot.
Oh.
Yeah, like when
You
your
must
client
attempt.
like never meets with you.
Must, right. Well, like of course we must make ourselves and our team available to prepare our parent client to testify. But you cannot hold me to that standard. What are you going to say? I'm not qualified to work for you because I didn't prepare 3 clients, but then you get, my client doesn't allow me to disclose to you that they declined my invitation to prepare.
Maybe we just say be available. The parent client's lawyer must be available to prepare the parent client to testify.
Or to take reasonable steps to prepare the client to testify. I think reasonable steps make sense because then it's you're actively, hey client, here's what I need to do for you, not waiting for them to come to you. But it's also like, I'm not going to be unreasonable and like go hunting my client down in all the homeless camps trying to find them when they're not contacting me, right?
Well, no, or
But,
even
well,
when they
that's why
are in contact with me, they're saying, I don't need that. No, thank you. I got this, Dawn.
And I do think saying make reasonable steps for me, I don't like that. I think it's a slippery slope because I'm not the babysitter. And so I want to make myself as the lawyer available to prepare the parent client to testify. But and I should be making steps, but I don't want to be held to it. Like, let's say, for example, how many letters did you send out? Did you go stand on a corner and did you send an investigator out to find your client? Like, I don't want that inquiry.
I think I must prepare the parent client to testify unless the client declines the opportunity. I mean, or, unless they don't want to. Nothing for my client without my client, nothing about my client without my client. If they're not in it, I work for them at their direction and discretion. I don't, right? I mean, unless I have reason to believe.
So, Dawn, except I like where you're going, but with your wording, where I see the problem being is, unlike in criminal, right? The states can call. And so I feel like, I just feel like we must make ourselves available to prepare the client. Now because I don't think a client can, the client can choose to get up there and take the fifth and be a shit or say nothing. But if we say, your phrase tacked on the end makes it to me read as if they have a choice to testify.
No, I meant they have a choice to work. They have a choice about whether they want to invest their time and resources in preparing. They do have that choice. They can say to me, I understand, and I'm not going to sit down and work on practicing to testify with you. I got it. I know what I'm doing. They don't have right. I think they have a choice about how much time they want to spend with their lawyer. If they were in private practice, if they hired me, they could say, well, I'm only prepared to pay you for 30 minutes of preparation and not 4 hours, right? They get to decide whether.
I don't disagree with the intent. I think, and just if I'm even understanding you wanting to add the clause at the end of it, the parent client's lawyer must prepare the parent client to testify unless they don't want to. I
think it's specifically unless they decline the preparation, not the testifying.
That's right. That's what I intend. But whatever language the group decides on, that covers the idea that sometimes our clients are going to decline our invitation to work with us.
So I'm going I flagged this because I think that we don't have consensus on what the language should be here, which is fine. Uh, it's just I don't think it's something that we're going to be able to resolve here today. And uh, ultimately, it's a it's a question that there's probably going to want to be more discussion about as to what that is. And eventually, I mean, somebody at OPDC is going to have to make a decision as to what that language is going to look like. So,
yeah.
Okay. Parent client's lawyer must identify, locate, and prepare witnesses, including expert witnesses consistent with the case theory and strategy for representation. I want to acknowledge that that's a lot.
Well, can you provide a little more information about what you mean by locate?
Yeah, because I don't like that line.
That's fair, right? So, if I remember right, and let me see if I can pull up the original joint task force report.
What I routinely say to my clients is they'll be like, I have all these people that will testify for me. And I'm like,
yeah.
That's fantastic. I need you to give me their names and contact information. And
yeah,
most of the time I don't get it, but like, I guess, yeah, I mean, it's sort of along the lines of when somebody says to me, well, my next door neighbor's cousin could testify about this. Like, am I obligated to send my investigator to
track them
talk to
down.
the next door neighbor and ask who their cousin is when my client's like not even doing anything to like help?
Okay.
I think it
Okay.
puts the burden.
Yeah. Go ahead.
I think I'm in agreement. Like my job is not to necessarily identify and locate.
Right. We're not
And
the
now
fact
then
maker.
it's saying expert.
Yeah, but you can identify them through the, materials you review.
You certainly can, but must means like I better have witnesses. I better have identified them. I better have located them.
Something about putting some of that on the parent might.
Yeah.
Well, I think what you're really trying to communicate is the lawyer must investigate and develop the facts, right?
Right.
So we need to be reading discovery, following reasonable leads, working with our clients. Our client is the expert on the facts unless, right? I can envision a rare occasion when they're not the fact expert. I'm the law expert and we're a team. So we shouldn't have a standard that requires us to locate, but we should have a standard that requires us to investigate so that we would be held accountable if our client said, I was at the store at noon or here are my 3 family members. I'm not sure they lived with me at the time. This is the address I think they're at. Can you follow the lead? Here's the best I got.
Sure.
And then you should fire the lawyer that doesn't hire an investigator to try to flesh that out more if it's meaningful.
Sure.
But if we never find them, that's not on us.
And there's a different section that's related to the investigation and the development of facts. This being court preparation. What if we
Kevin, I do not want conflicting. I don't want conflicting sections.
Good point.
No, and what I'm trying to say is, what if we modify this to instead prepare witnesses who have been identified and located? That way, we're dealing like the investigation part where you find and source them. That's an investigation. Court preparation, we're talking about you've located folk, you've identified them, get them ready for court.
Yes, I like that.
Okay.
should we, I'm not trying to beat a dead horse, but can we must make best efforts? I say that because now we get to including expert witnesses, and I can't hire my expert witness unless state gives me funding.
You also can't prepare witnesses who aren't willing to talk to you either.
Right.
Yeah, I would like it to say the parent, client, lawyer must make best efforts to identify, locate, prepare, blah, 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 blah.
Can we just take the same, take reasonable steps to prepare from the previous one? Okay.
Yes.
Hold on,
Tara,
I'm going to
can you
switch this back to
see-
simple markup. There.
Are you looking at Kevin's screen?
I'm not because I couldn't have Teams, but
Okay,
I'm reading.
I was wondering because
I'm on page 34 and
he's
I'm
been
reading
changing the language.
Okay.
Yeah, I'm editing in real time. Okay, so it reads now, parent client's lawyer must take reasonable steps to prepare witnesses, including expert witnesses, who have been identified and located consistent with the case theory and strategy for representation. Okay, I'm seeing a lot of nodding heads. All right, it's past 5, and that's it. I, at this point, am gonna hand the draft and the work group off to Annie to help complete. Annie, you're still on, right?
Yes, I am
Yeah.
still here.
Okay, I don't have everybody's.
To filling your shoes in this endeavor. So.
Okay. I don't know if you wanted to go through and do any scheduling with everybody while they're here, or if that, do you want to just handle that by email?
What people here prefer, if people are available, want to do that now and it's easier, I'm happy to do that. I can also say, yeah, all right, let's schedule that now then, so we can get it on the calendar. Let me pull up my calendar. Do we want to look 1 week or 2 weeks?
What's our homework going to be? That'll dictate how many weeks.
I am not sure. Probably, why don't we do 2 weeks and I can get with Kevin and provide more information to kind of catch up because I've been a little bit slow on these. So let's look at the week of the 22nd. We could do, does this time work Tuesday at 4 to 5?
That week it won't work for me. I'm scheduled to be in a trial that'll run through that, but I would be free on Wednesday that week.
Just a note, after 5 usually we're good if I have to pick my kid up between 4:30 and 5.
Are people okay with a 5 o'clock meeting? And would we, okay.
This was
This has been a rare 4 o'clock meeting.
I know. I have was on some of those earlier ones, but I just always like
usually these have been 5 o'clock on Wednesdays.
Do we want to do 5 o'clock on Wednesday? Okay. Let's do it. I will send out an invite for the 24th at 5 o'clock for 5 to 6 o'clock. We'll go from there. And I will make sure to do my best to fill Kevin's shoes, but I also may ask Kevin to join this work group as a provider if he is able to kind of wrangle his caseload, because it will be quite a transition back to casework from the joy that we have here.
But he's going to miss all of us except Rebecca. And so
very
absolutely going to miss everybody.
Are you going to the consortia? I don't know Clackamas County structure all that well, but are you going to be in the consortia with Rebecca?
Yeah.
Well, lucky Rebecca.